You're listening to the Study Legal English podcast, the world's first legal English podcast, helping lawyers and law students become fluent in legal English. Hello and welcome to episode 58 of the Study Legal English podcast. I am your host Louise, and today we are looking at alternative dispute resolution, and specifically arbitration. Besides from seeking justice through the courts by means of litigation, parties can try to resolve disputes through a number of alternative and less formal mechanisms. These are known as forms of alternative dispute resolution, ADR. And there are many forms such as negotiation, mediation, conciliation, arbitration, and adjudication. Over the next 3 episodes, including this one, I'll be looking at each one of the main forms of alternative dispute resolution, those being arbitration, mediation, and conciliation. And today we're focusing on arbitration. As you listen, pay attention to the vocabulary I use and try to answer the following question. What are some common remedies that an arbitrator can award? You can send me an email with your answer to louise@studylegalenglish.com or find me on Facebook or Twitter. Just search for Study Legal English. The answer will be given in the next episode. So, let's get started. Arbitration has been around for the longest out of all the forms of ADR, and it dates back to the late 18th century when it was first used to settle disputes between the British and the Americans during the American Civil War. Nowadays, it is a popular form of dispute resolution for international commercial transactions, and very often contracts contain ADR clauses setting out the specific details for resolving disputes by means of arbitration. For example, parties will choose where the arbitration will take place. This is called the seat of the arbitration. They will also choose the law to govern the dispute and the language the case will be heard in. Most cases involving arbitration are where parties have voluntarily chosen it as the form of dispute resolution in their contract. However, sometimes it is mandatory or compulsory due to certain legislation. If a party is obligated via a contract to use arbitration as the means to settle disputes, and a party breaches this agreement by starting traditional court proceedings, the other party, let's say the non-breaching party, can apply to the court for something called a stay of the court proceedings. And this means they can stop any further legal proceedings in the courts from taking place. At least with regards to England and Wales, most cases can be submitted to arbitration, with the exception of those dealing with criminal matters, insolvency proceedings, and employment issues where the employee has a statutory right to have his or her case heard by an employment tribunal. So, what is the process? Arbitration is a private adjudicative process. This means that it is a process involving a judge or an arbiter or an arbitrator, as we call it for arbitration, who reviews evidence and legal arguments and then comes to a decision about this case. With arbitration, disputing parties, this can be 2 or more parties, submit their case to an impartial specialist tribunal where it is heard by a neutral third party called an arbitrator or an arbiter, or even a panel of arbitrators. Any person can be an arbitrator. There are normally no formal legal requirements or necessary qualifications, except for the requirement that the arbitrator must be impartial. This means he or she does not have any preference or interest in the dispute or with the parties. However, normally the arbitrator has specialist knowledge in the subject area of the dispute. So, The submitting party, the party that makes the claim, is called the claimant, and the responding party is called the respondent. And so the case is heard by the arbiter. Depending on what the parties have agreed upon in their contract or what they are obligated to do by law, the arbitration process can differ. For example, it may resemble something quite similar to the court process, with witnesses and evidence being called. However, normally it's more informal, with no formal cross-examination of witnesses or swearing of oaths. The arbitrator decides the case based on the facts and makes an arbitration award, which is binding on the parties. This means parties must follow it. The decision is also final, meaning that normally there is no option to appeal. The decision may only be set aside by a court if there was a serious problem with the decision-making process. And in England and Wales, there are a number of organisations that resolve commercial disputes through arbitration. These are the International Chamber of Commerce, the London Court of International Arbitration, and the London Maritime Arbitrators Association. Some advantages of arbitration are that it is less formal, faster, and cheaper than the civil court process. The arbiters have expertise in the field of the dispute, and the proceedings are private and confidential, which can be beneficial to companies who don't want to damage their public reputation. Additionally, where the dispute involves parties from different jurisdictions, sometimes an arbitration award is easier to enforce than a judgment from a different jurisdiction. On the other hand, some people argue that in some instances, the cost of arbitration can be very high and the procedures lengthy. Therefore, it's not actually that different from the traditional court process. In fact, it can be worse because it can be even more difficult to appeal an arbitration decision than a court decision. Clearly, it's a process that has its benefits, but which is not a perfect process yet. So, now that we've learned about arbitration, let's discuss some of the key vocabulary. First, you'll hear the vocabulary. There will then be a beep and a short pause for you to repeat the vocabulary, and this is followed by the definition. Then we'll hear an example sentence, and there'll be a beep and a short pause for you to repeat the new phrase. Number 1, repeat after the beep. Arbiter or arbitrator. Definition. An arbiter or an arbitrator is an impartial, in other words neutral, third party appointed by the parties in a dispute in order to resolve the dispute through arbitration. Example, repeat after the beep. The arbitrator heard the evidence and considered the facts related to the dispute. Number 2, repeat after the beep. Adjudicative process. Definition. An adjudicative process is a process involving an adjudicator, such as a judge or an arbitrator, who reviews evidence and legal arguments and then comes to a decision about this in order to settle or determine a dispute. Example, repeat after the beep. Arbitration is an adjudicative process. Number 3, repeat after the beep. Arbitration award. Definition. An arbitration award is what the arbitrator decides. It is like a judgment or a decision of a judge in court. An arbitration award does not necessarily mean that any award has actually been made, such as an award for damages for the claimant, and indeed the arbitration award may go against the claimant. Common remedies available to parties, and which may be awarded, are damages, meaning compensation, or an injunction, ordering parties to do or refrain from doing something, specific performance, ordering parties to perform their contractual obligations, or rectification, where the contract is set aside. Example, repeat after the beep. In the arbitration award, the arbitrator ordered the respondent to pay damages to the claimant and the costs of arbitration. Great, so that's the end of today's episode. In the next one, we'll be finding the answer to our question: what are some common remedies that an arbitrator can award? And we'll be looking at mediation. If you're interested in finding out more about ADR, I suggest looking on the website of the Centre for Effective Dispute Resolution, which is www.cedr.com. And of course, don't forget that if you're a Podcast Pro member, head over to studylegalenglish.com/episode 58 for all your member benefits. As always, if you like the show, please share it with others and send me your comments to Louise at studylegalenglish.com.